Well, good afternoon. I always hate to do the last session of the day because I hate being the only one standing between you and happy hour. You know? But nevertheless, that's how it is. I always talk about Fair Labor Standards Act at TPC, but this year we're going to do a little bit on EEO as well. Let me start off by asking a simple question, a rhetorical question of what do we mean when we say discrimination? So, my good classroom monitor, Melissa, is wearing a jeans jacket. I hate jeans jackets. You're fired. Is that discriminatory? Well, it's not smart. It's unfair. It may even be, immoral or fattening. But that in itself is not discrimination. Now, if I fired her because there's a woman inside that jacket, that's a different story. Discrimination doesn't just mean taking an adverse action against an employee. It means taking an adverse action because of their membership in a protected group. So, there is no general common law requirement for fairness or just cause in most states, and certainly not in Texas, and no generic wrongful termination cause of action. Employees will say, I'm going to sue you for wrongful termination. Well, there's no such cause of action in Texas. If you violate a specific statute, then obviously there's a cause of action. But discrimination is not just, I didn't like how you treated me. Discrimination is an adverse employment action, didn't hire me, fired me, discriminated in my terms, conditions, or privileges of employment based on membership in one or more protected groups as created by statute. Okay, so the starting place, obviously, what are the protected groups? The broadest anti-discrimination statute and the most famous is the Civil Rights Act of 1964. Now, when this law was first passed, the big impact was Title I, Section 1, the public accommodation section. I mean, remember, all through the civil rights movement, you had issues of sit-ins at lunch counters, and people were denied access to hotels and restaurants and other public accommodations because of race. And Title I addressed that and pretty much eliminated that, we hope. And so the impact of Title I is minimal today, but Title VII, Section 7, prohibited discrimination in employment, and that continues to affect us every single day. The protected groups in Title VII of the Civil Rights Act: race, color, religion, national origin, sex, and religion. So race, color, national origin, sex, and religion. Here's an interesting story. The Civil Rights Act was filibustered in the Senate, and it had the longest filibuster in history. The Southern senators fought and fought and fought to get that bill defeated. And probably the only reason it got through was that Lyndon Johnson was president, and he knew how to twist arms better than almost anybody. But a last-ditch effort was made to oppose the bill by adding sex as a protected characteristic. Now think about that. Back in 1964, public opinion had gotten to the point where inevitably they were going to ban race discrimination. But to ban discrimination based on sex was considered so radical that it might defeat the bill. The amendment was added by the enemies of the bill, saying, well, there's no way that anybody's going to vote to outlaw discrimination against women. Well, the Senate fooled them, and they did in fact pass this bill to protect not only based on race, color, national origin, but also based on sex. Now, elaborating on sex, the act was amended in 1978. Let me give you the backstory. In 1976, the Supreme Court decided a case called Gilbert versus General Electric. In that case, General Electric had a benefits policy that didn't apply to pregnant women. Applied to everybody else, didn't apply to pregnant women. And the Supreme Court actually ruled that it was not discrimination based on sex because it only discriminated against pregnant people. Apparently, it escaped the attention of the Supreme Court that only women can become pregnant. But Congress changed that on them 2 years later. They amended Title VII by adding the Pregnancy Discrimination Act. So now the terms because of sex also includes, but are not limited to, because of or on the basis of pregnancy, childbirth, or related medical conditions. And women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes, including receipt of fringe benefits, as other persons not so affected but similar in their ability or inability to work. So, Title VII's prohibition against sex discrimination also applies to women affected by pregnancy or childbirth, and they are to be judged depending on their ability or inability to work. Now, one thing, the Pregnancy Discrimination Act did not require maternity leave. What it did do was state that pregnancy must be treated like any other temporary disability, including maintenance of health, insurance, and income maintenance benefits, same as everybody else. Seniority continues, and a BFOQ exception is very narrowly limited. What do I mean by a BFOQ? BFOQ is an acronym for bona fide occupational qualification. Are there any jobs for which pregnancy or the ability or the possibility of becoming pregnant is a bona fide occupational qualification? The Supreme Court decided a case called Johnson Controls. Actually, UAW, the union, was involved. UAW versus Johnson Controls. Johnson Controls was a factory. It manufactured batteries. Batteries are made out of lead, and lead causes birth defects. So Johnson Controls, in an effort to prevent it from being sued by its employees, or at least, because remember, even if the woman were injured, she'd be covered by workers' comp, but not her child. So in an effort to eliminate lawsuits, they had a rule: no fertile woman could work in any job where she could be exposed to lead or whether she could be transferred to such a job. The definition of fertile woman was any woman between the ages of 16 and 59 who did not have medical evidence of sterility. The upper limit is ridiculous. The lower limit at 16, why was a lower limit at 16? Because the child labor laws don't let you work in a factory if you're under 16. So, this case posed enormous oh, and by the way, the jobs where you could be exposed to lead were all the higher paid jobs in the factory. So, needless to say, the women were not necessarily thrilled about not being able to take those jobs. So this case goes all the way to the Supreme Court, but it caused fits. The district court ruled in favor of the company. It gets appealed to the Seventh Circuit. A 3-judge panel of the Seventh Circuit reverses the district court and rules for the employees. The whole Seventh Circuit, in what we call an en banc decision, meaning all the justices, there's I think 15 of them on the Seventh Circuit, reversed the 3-judge panel and ruled for the company. So then it goes up to the Supreme Court, and the Supreme Court shows us why they're the Supremes. 9-0 ruled in favor of the employees. They had no trouble with it at all. They said that even if there's an increased risk, you cannot, as a classification, deny women access to these jobs, even though there might be an increased risk of damage to a fetus. And so that's the rule. Pregnancy as a BFOQ is extremely, extremely limited. Indeed, gender as a BFOQ itself is extremely limited. The only two cases I know where it was accepted, prison guards in a woman's prison and fitters in the bra and lingerie section of a department store. You could say only women can get those jobs.